Made please also. But I have a matter which was filed yesterday morning hours. It was numbered and registered, but somehow it is not listed, my lord. There is some urgency in the matter. It may be, I may be allowed to move it unlisted, my lord, after the motion.
Today?
Today. It will take only hardly 5-6 minutes for your lordships.
Okay.
Take this.
Please, Your Lordship. The allegation is regarding embezzlement of money. Let me take Your Lordship to the FIR at page 17. My husband has embezzled certain money from this particular informant who is the owner of a company. Now, if I
Your husband is the?
he was serving as a clerk in that particular company.
Your husband?
Yes, my husband. Now, he has been granted bail by this honorable court. Your Lordship would find that's an interim protection. The Lordship would find it at page 19. On 21st of May, he was granted interim protection, madam.
When the next date is fixed?
I'm sorry, madam. Next date is on 16th, madam. 16th of June.
16th of June.
Yes. Next date is fixed for the husband's matter. The next date is 16th
That's
of
right.
Yes, madam. Now, what
CD has been called for.
call, my lord. Now, what has happened is, if your lordship would kindly peruse the second order passed in my husband's case, that is on page 22.
I have gone through it. Okay. Yes, madam.
Lordship, here, Lordship, in the, there are two, Lordship, AB, they have annex, Lordship. One is on 21/5/25, wherein the Lordship, this applicant husband was granted interim protection, Lordship, to appear before the IO. But he was, Lordship, he did not appear, Lordship. So on the 29/5/25, Lordship, it is the honorable Lordship, the court has Lordship been informed that this accused was not appeared before the investigation officer for his recording statement. That's why Lordship that the BP has directed to produce the updated case diary on the next date. Let me not, Lordship, he is not cooperating with the Lordship
I appeared
investigation.
on second.
No, we are not concerning with the case of the husband of the petitioner.
Lordship, main Lordship, that's why Lordship, they let the CD come, Lordship. This is only on next as a 16/6, Lordship.
Allegation is mainly against the
Husband, madam.
husband.
Only at the very end of the affair, my name has
Lordship,
been
then
taken.
why he's apprehending, Lordship, then? Why she's apprehending that, Lordship? Apprehension is,
No, her name is also there.
yes, that's why, Lordship, then let the CD
No,
may
her
come,
name is
Lordship.
also there, but not in respect of embezzlement of the amount of the soap. But the allegation is that she has received the amount in her bank account.
That's why, Lordship, something is there, Lordship. That's why she's avenging the arrest.
You produce the CD, we will see later on.
Yes, Lordship.
Heard Mr.
P. Bharadwaj.
Learned counsel for the applicant and Ms. Page, learned additional PP for the state respondent. Apprehending arrest in connection with
Itanagar PS 76 of 25.
Itanagar PS case number 76 of 2025 under section 408 120B IPC. This application under section 482 of the BNSS 2023 is prepared by applicant Yusnakos. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Karka Gadi with the officer in charge Itanagar PS on 8/5/2025. So, Mr. Bordas,
Madam.
come to page number 5.
Madam. Yes, ma'am.
So, Josnakos is the present applicant is the wife of Jointo Bora or Padma Bora?
Padma Bora. Jointo Bora is her elder brother.
Okay. The essence of allegation in the FIR dated 8/5/2025 is that the husband of the petitioner, namely Padma Bara, was working as manager in the shop of the informant in the name and style of Z Consumer Goods. And over the period of time, he has embezzled a sum of rupees 1,69 lakhs 13,852 rupees. 52 rupees. And the allegation against the present applicant is that the site accused, namely Padma Bara, has transferred some of the amount in the account of the present applicant. Mr. Bhardas, learned counsel for the applicant, submits that the husband of the applicant, namely Padma Bara, has already preferred one anticipatory bail application being AB number 71 of 2025 before this court and white order dated 21/5/2025. This court was pleased to grant interim protection to the applicant and call for the CD fixing the matter on
the same date, Lordship. And is both the matter may be clubbed together, Lordship, on the same date.
no, that's all right. When the next date is
16th of June.
16th of June, Lordship.
Earlier it was fixed on
Earlier it was fixed on 29th of May. ma'am.
29th of May 2025. And that the present applicant is ready to cooperate with the investigating agency and will appear before the investigating agency as and when required. And therefore it is contended to allow this petition. For contra, Ms. Hage, learned additional PP has vehemently opposed the petition on the ground that the husband of the petitioner has already been granted interim period bail by order dated 21/5/2025, and he was directed to appear before the investigating officer on 29/5/2025.
No, ma'am, 10th of June, 2025.
10th of June.
Madam.
On
or
10th of
before
June 2025. But he has not appeared before the IU. And therefore, Ms. Hage submits that at this instance, only CD may be called for. And after going through the same on next date, the application of the present applicant may be considered. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record and also perused the order dated 21/5/2025 in AB number 71 of 2025, by which this court was placed to grant interim period bail to the husband of the present applicant. Further, from the FIR dated 8/5/2025, it appears that the allegation is mainly against the husband of the petitioner. The allegation against the husband of the applicant. The only allegation against the applicant is that she has received some of the amount in her bank account. Be that as it may, the learned additional PP shall produce the case before this court on 16.
Lordship.
16. And in the interim, considering the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to grant the privilege of interim period bail to the applicant. Accordingly, it is provided that in the event of arrest of the applicant in connection with Itanagar PS case number so and so under section so and so, she shall be released on interim period bail on her executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions.
Lordship, she may appear before the IO before on 10th, Lordship, because on 16 we are calling for the case hearing.
Report I want that.
Much obliged.
May I please, your lordship?
Where is Mr. Pisa?
He is.
My lord, I am appearing through virtually, my lord. I
Virtually.
think I have some problem with my video, my lord. I'm here, my lord. I'm out of station, my lord.
Out of station, okay.
Yes.
Lordship in mailers.
So, Mr. Pisa, what is your submission?
My lord, this is a very interesting case, my lord. A file noting has been challenged. Whether a file noting can be challenged by way of writ petition, my lord, that is another question, my lord. See, my lord, last time also I have submitted, my lord. This is only an internal communication, my lord, which is yet to be culminated by an order, my lord. The order has to be passed, my lord. This is only an internal communication, my lord. Now, internal communication can be, whether internal communication can be challenged by way of writ petition, my lord, whether a certiorari can be sought, my lord. This is only a file noting, my lord. Last time also I have submitted, this is only a file noting. My lord has also observed, my lord, in the order, my lord. This is only a file noting, my lord.
Maybe, but it is a document before the court
Yes, my lord.
and it is produced by none other than you.
Yes, my lord. I have accepted that. That is our submission was that, my lord, this is only a, my lord, internal communication which is yet to be culminated in the order. But some decision has been taken. That decision has to be finalized by way of order, my lord.
That's all right, but from perusal of this note sheet, it becomes apparent that in spite of being L1 bidder,
My lord.
you were not going to settle the tender in his favor.
My lord may see the last portion of the, my lord, page 123, my lord.
Yes.
This is the internal communication between the director and the joint director. My last page, my last line, my last paragraph.
Hmm.
There was a query made by the director, my lord.
When?
My lord, it is in, my lord, page number 123, my lord.
Hmm.
Note number, my lord may see note number 3, my lord.
Yes.
There were several complaints on engineering tender also, and so has the complaint been resolved, my lord?
Hmm.
The complaint blocks NIT have excluded from this proposal. In this instant case, there are no complications. This is of 35/2025.
Hmm. Hmm.
So, my lord, my lord, this internal decision, my lord, has to be
Hmm.
culminated by way of an order, my lord. Now, my lord, they have, my lord, challenged the file noting, my lord.
Maybe, but it is your decision.
Yes, lordship.
My lord, yes, my lord. This communication, my lord, this file noting, my lord, it says, my lord, the order has to be passed, my lord. Now, order has not been passed, but some decision has been arrived, my lord. But, my lord, that has to be culminated in the order, my lord. Now, till date, my lord, the order has not been passed, my lord. Order has to be passed, my lord. My lord, may kindly issue the notice only, my lord.
In the meantime, lordship, this has to be stayed also because it is apparent from the
file
face of the
noting, my lord,
record.
my lord,
It
file
is
noting
apparent
does
from
not
the
give
face of
any
the
vested
record.
right to the, my lord,
The
petitioner.
respondent authority is going to give the work to the L1, L2 lordship, despite the fact that I have duly complied with all the conditions which has been prescribed in the NIT lordship. And the more
My lord,
interestingly, lordship,
my lord, there is one case of Pimpri Chand, my lord, Pimpri something, my lord, which says a file noting does not give any right to anyone, my lord, until it is culminated by way of an order, my lord.
In which decision?
Pimpri, my lord, I can submit the decision, my lord, to the, my lord,
let him come with the
to the
affidavit
petitioner.
lordship so that they will clarify whether they are taking a decision to give about work about to the L2 or L1 lordship. Because on the basis of this note, this is an official note lordship. This is not a human note lordship. This is an official note. On the basis of this, they are going to pass a subsequent order lordship. That is definitely will pass an order against me and lordship. And they will about the work to the L2 lordship. This is exactly what we alleged in the first writ petition as well, lordship.
Now,
My lord, may reserve the
my
order.
humble
I will
submission,
submit
Lordship,
the
let the
judgment.
notice, let the notice go, and so that may be fixed, so that they will come up with the affidavit, Lordship.
That would be completely wrong, my lord.
There is-
How can
there
a
is-
file noting can be, my lord, state, my lord? My lord,
There
I will
is-
submit one judgment, my lord. I will submit to the Peskar, my lord. The
When?
judgment, my lord.
When?
Today itself, my lord. Today itself, my lord.
At what time?
My lord, by 1 hour, my lord.
Okay. Let us see the judgment.
My lord, my lord. Obliged, my lord.
My lord, my lord, in earlier round of litigation, my lord, on 1st April 2025, my lord, I moved a writ petition, my lord, challenging the order dated 28th January 2025, my lord, two order passed by the Deputy Commissioner, my lord, wherein, my lord, the earlier writ petition, my lord, 141 of 2025, my lord, this was withdrawn with liberty to file a fresh, my lord, to reflect the record that whether the special prayer for allotment was made by the petitioner or not, my lord. After withdrawal, my lord, I contacted the petitioner, and they come to know that against the order of the Deputy Commissioner dated 28th January 2025, my lord, they filed a representation, my lord. Now, after when I checked this, gone through their representation now, my lord, it's found that this entire order of the Deputy Commissioner is appealable order, my lord. So since they have already filed the representation before the Deputy concerned Secretary Land Management on 25 February 2025, my lord. My lord, this is I come up with this writ petition with limited prayer to dispose of that appeal dated representation oblique appeal dated 25 February 2025 pending before the Secretary Land Management, which is the appealable, my lord. It is statutory appeal, in fact, my lord. I'll just come to detail, my lord, in this, my lord, regard. My lord, there's a plot of land measuring around 30,000, my lord, which has been in possession of the petitioner for many decades, my lord. So in this regard, my lord,
No, many decades, that's all right, but do you have any document to substantiate it?
my lord, yes, my lord. My lord will see, my lord, I'll just come to my lord. My lord, prior to that, my lord will see, my lord, the order dated, my lord, first, my lord, I'll take, my lord. First, the round of series of verification was done, my lord. The first allegation made by the Donipolo Vidya Bhavan, my lord, is said that somebody or petitioner, someone other has encouraged the allotted land, my lord. In this regard, to ascertain whether the enforcement was done or not, my lord, the Land Management Department and Deputy Commissioner, my lord.
You tell me, under which provision of law this order was passed?
My lord, that, my lord, that Deputy Commissioner, my lord.
Yes.
My lord, Deputy Commissioner order, my lord, since it's related to land allotment related, my lord. So we now it is prima facie, my lord, it would be under Land Settlement Record Act 2000 only, my lord. Under Land Settlement Act 2000, my lord, any order passed by Deputy Commissioner is appealable, my lord. It's appealable to the can be appealed to the Secretary, my lord. It's a statutory, there's appealable appeal provision.
Now, where the appeal is pending?
Yes, my lord. That is why, my lord.
No, where it is pending?
My lord, it is before the Secretary Land Management, my lord.
Okay.
My lord, just, my lord, see,
When you have filed the appeal?
my lord, 25th of February 2000, my lord, 5, my lord, recently.
Without notice whether it was admitted?
My lord, that is why they have not been taken up, considered. That is why my I before this honorable conval is with direction, my lord, with prayer for considering disposing of representation within limited time bound, my lord.
Just Lordship, this is just to relate a matter. Earlier Lordship, withdrawal order, Lordship may kindly go through the withdrawal. They have not annexed this
My lord,
withdrawal order also, Lordship.
my lord, that
In
is the
this,
way
Lordship,
I have already, my lord, intimate this, my lord, when we know that that's the appeal representation is pending and it is appealable, and this representation it is under in terms of the provision, my lord. when it is pending, my lord, in merit, this honorable court may not be able to go, my lord, when matter is pending before the authority, my lord. That is why, my lord, it can be considered on merit only after disposal of the representation only, my lord. That's why, my lord, this disposal is required, my lord.
Lordship, here they are the encroachers, not allotee,
My lord,
first of all. And then the encroachers eviction, Lordship, the appeal will lie before the deputy commissioner only.
but that
Lordship. Then how come they can, Lordship, they can appeal before the secretary?
my lord, I'll come to the
Lordship.
details, my lord. Just
And
for,
Lordship may kindly go through the withdrawal order. Is in withdrawal order, they
Page
did not,
number?
Lordship, because
Ma-
it's in my this one, Lordship.
Page number?
my lord, withdrawal order is here, my lord.
We have not annexed, Lordship.
My lord, just.
The petitioner had.
My lord, when I said,
Also.
when I come to know that the representation is pending, my lord. Now, practically, my lord, on merit, we cannot, my lord, consider this matter, my lord, unless the disposal is, representation is disposed of, my lord.
The same matter has been taken up by this honorable court already, Lordship.
That is why, my lord, liberty to file a fresh, my lord.
But then, Lordship, here, in the order dated 28/1/2025, passed by the Deputy Commissioner Capital Complex, Itanagar, it has been mentioned that WPC so and so was disposed of by an order dated 31/8/2015 with a direction to the petitioners to submit a fresh representation, and accordingly representation dated 3/9/2015 in continuation of earlier representation dated 30/6/2015 was submitted before the Deputy Commissioner Capital Complex, Itanagar. From the copy of the representation dated 3/9/2015 available on record, the court does not find any prayer made therein for allotment of the land. This was the reason.
My
And
lord,
then they withdraw the petition, Lordship. They haven't, Lordship, applied for the land allotment also. They are encroachers.
my lord,
So how they can now against the deputy commissioners? Deputy commissioners is appellate
No, no.
order only. Lordship.
Where the appeal will lie?
Lordship, this was original was asset officer's order only. That asset officer's order is in, Lordship, page 91 to 81.
my lord, just, I'll just come,
This is the original order, Lordship.
Letter complaint, 90? Page number?
91, Lordship.
That is the appeal.
Yes. And against this appeal, they have gone to the Lordship Deputy Commissioner. Appeal has been filed against the estate officer's order to the Deputy Commissioner, Lordship. And after Deputy Commissioner's, Lordship, order, they cannot go to the secretary again. This is Lordship,
Deputy
eviction.
Commissioner is the final authority.
Yes,
my
Lordship,
lord,
in
I'll
encroachment,
also the, my lord, also
eviction
the,
order, Lordship.
also on the provision, my lord, how it is appealable, my lord. That's why I should, my lord, that is, yes.
Whether second appeal.
They are
will
not
lie.
Lordship.
My lord, is lying, my lord. That is why, my lord, I'll come to the point, my lord. My lord will see the first, my lord, CRP on the basis of which this entire episode come up, my lord. Page 68, my lord, there's earlier litigation was.
Let us do one thing. Madam, you can you obtain instruction whether they have admitted the appeal or not?
Lordship.
Where is the appeal?
Lordship,
My lord, appeal is
Lordship,
at,
if not, can this matter be list again?
No,
of,
no, if it is not
124.
appealable
yes.
or it cannot be admitted, then dismiss it.
yes, my lord, at least we can, that will, at least we can have an opportunity to challenge, my lord.
Let this be on coming Tuesday, Lordship. List again.
This represent Annexure 19.
Yes, my lord. It's an appeal, my lord, under section, in terms of under section 83, my lord, of the Arunachal Pradesh Land Records Act 2000.
83.
Yes, my lord. I'm specifically pleaded, my lord.
Para number?
Appeal section 3, my lord.
In which paragraph you have mentioned it?
My lord, I have mentioned, my lord. My lord, at page 29,
Paragraph number.
para 28, my lord. Aforesaid order dated passed by is appealable under section so and so, my lord. Therefore, it is being agreed by the aforementioned order that so and so has preferred appeal so and so before so and so.
So you can dispose of the appeal in either way.
Yes,
If
my
it
lord.
is legally, it can be admitted, you admit it. Let
Either
them admit
reject it, my lord. At
Yes.
least.
If it is not maintainable, then you can reject it.
Lordship.
Hmm?
That can.
So we'll close this application by directing the appellate authority to dispose of the appeal in
Yes,
either
ma'am.
way.
Within 15 days.
Within 15 days. Okay. Heard Mr. Tagum, learned counsel for the petitioner, and Madam J. Itel, learned additional PP for the still use from that. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order passed by the Deputy Commissioner Itanagar Capital Complex in appeal number 02 of 2024, dated 28/1/2025 in respect of DPBB versus the Saru Tahar and others.
Lordship,
And-
the Deputy Commissioner's order is in page 117, Lordship.
Okay, it is to be
It is-
entered by the impugn order dated so and so, the learned, the Deputy Commissioner Capital Complex, Itanagar Capital Complex has set aside the order dated 28/9/2024 passed by the ESC cum state officer ICC.
And on
Lordship,
same day, my lord, and another.
Honorable
again,
Court
again.
has,
On same day,
this
my lord.
Honorable Court has set aside the Lordship. And it was remanded back. After direction of this Honorable Court only, Lordship. It is. That's why, Lordship, I am saying this could not have been appealable to the Secretary, Lordship. Against this order, they have gone for appeal, Lordship.
Yes. And
117.
Set aside the order dated 28/9/2024 passed by the ESC cum state officer ICC Itanagar Capital Complex and directed the petitioners to carry out self-eviction of their occupation from purported government land within 2 months.
Lordship.
2 months. Mr. Tagum, learned counsel for the petitioner submits that being agreed by the order dated 28/1/2025, the petitioner has preferred one appeal, one representation in the form of an appeal under order, under
Appeal
section,
dated, under.
under section
83 subsection 2A,
Under section 3, 2,
A, small a,
A,
Arunachal
the-
Pradesh.
Arunachal Pradesh
Land Settlement Records Act 2000.
Land Settlement Act 2000, and the respondent authority, no, before the Secretary Land Management.
Yes, ma'am.
And the Secretary Land Management has neither dismiss, neither admitted the same nor dismissed the same. Dismiss the same, and therefore Mr. Tagan submits that this writ petition may be disposed of by directing the Secretary Land Management, who is arrayed in the petition as respondent number
2, madam.
Respondent number 2 in a time-bound manner. Ms. Itel learned additional senior government advocate submits that she has no objection if this writ petition is closed by directing the respondent number 2 to dispose of the representation dated 25 to 2025 filed by the present petition. By taking note of the submission of learned counsel of both the parties and also considering the facts and circumstances in the record, and as agreed upon, this court is inclined to dispose of this petition by directing the respondent number 2 to dispose of the representation dated 25 to 2025 filed by the present petitioner by a region order, and after affording an opportunity of being heard to them within a period of 15 days from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 2 within 2 working days from today.
My lord, can my lord, there be status quo order, my lord,
No,
because
sir.
my lord,
Cannot
this,
be, Lord.
that order, my lord, it is directly contravention to the decision of this honorable court. Already the last matter when
Okay, till disposal of the representation by a speaking order, both the parties shall maintain status quo over the disputed land.
deeply abhorrent.
My lord, before my learner friend. Next submission, my lord. In item 4 and 5, my lord. In this connected representation, my lord, we have already, I have filed two caveat applications, my lord, caveat 52 and caveat number 53,
Okay.
which are not before this.
Okay. Caveat will be hard. Caveat is the research.
Look at the, yes, I'm for the petitioner in this case. Item number 4 and 5, they are same matters, similar matter. So, I'm agreed by the manner in which the NIT dated for 16 April 2025 has been conducted and my firm has been rejected. That is in page number 21.
Your averment is that you are the L1 bidder
Yes.
and the work has not yet been allotted to you.
The work was, as per, since I am the L1 bidder, I was expecting that I shall be given the work. But then, after opening of the tender, I was declared the L1 bidder. So when they didn't, about the work, even after passage of more than 2 weeks, then I wrote an application with authority.
No, is there any document to show that you are the L1 bidder?
No, because they are not providing any document, but I have written an application, Your Lordship, to the authority where I have said that I have been declared the L1 bidder. So kindly the tender may be awarded to me. That application, Your Lordship, is in page number 25 for the petition.
No, that representation all right, but is there any document to support your contention that you are the L1 bidder?
Not as of today, no, Your Lordship. As of today, no.
Then
Because,
on what basis you are filing this petition?
because Your Lordship, now since I am the L1 bidder, and they are refusing to give me any documents.
Yes, Mr.
Madam,
Soikia,
madam, I
whether
am-
he is the L1 bidder.
No, absolutely no. Well, I am appearing on behalf of the respondent number 3, the executive engineer, Pasigat Municipal Corporation Council matter. Well, we have enclosed all the documents in the KVL also matter. For reference matter, I have those copies matter. The pursuant to the NIT matter, the board was constituted and the matter board has evaluated the bids matter. And accordingly, my lord, L1, my lord, he is not L1, my lord, my lord, accordingly, my lord, L1 was, my lord, recommended. Pursuant to that recommendation, my lord, agreement was entered between the parties, executive engineer and the L1, my lord, and the, my lord, work was also issued to the, my lord, lowest bidder, my lord. And the work is in substantial progress, my lord.
Here is one
And
document.
he has not attempted anything, my lord, in the requisition saying that, my lord, he has applied for RTI, my lord, to get these documents also.
Now, Your
But he
Lordship,
has not approached the executive engineer also, my lord.
now, Your Lordship, if I go for the RTI, how many days it will take? It will take more than 5-6 months. By the time I won't be able to approach this court. So my friend, at least today, notice may be issued. And let them come with proper affidavit, Your Lordship, with valid documents. Your Lordship, I'd like to draw your attention to page number 28, in which they have written one letter to me saying that of return of my EMD.
He was not found to be a successful responsive bidder. That's why, my lord, he is, my lord,
I
the
will,
earnest money was also returned.
yes, that I'm coming, Your Lordship. So page number 28, Your Lordship. That is dated 8 May 2025.
No, whether you have enclosed those documents with this petition. That earnest money was returned to you.
The documents which they have given me, returning my earnest money, that I have anything.
Page number.
Page number 28, Your Lordship. One very important issue, Your Lordship, I'd like to point out. Page 28 of my petition.
No, if you are not the L1 bidder, then
No, I am the L1 bidder, Your Lordship. Your Lordship, if you look at my representation, there things will make clear. My only grievance is that
so yes, Mr. Saikia, do you have any other document to show that he was not the L1 bidder?
Well, I have given the, my lord, the board posting also, my lord. The first page is the board posting, my lord. Kindly, my lord, see the second page, my lord, the recommendation, my lord.
Drill number 1. What number 2?
In writ petition, my lord, item number 4, my lord, they have challenged the, my lord, the work, my lord, in respect of ward number 2 and my lord 7, my lord. And 4 days, my lord, I have given the, my lord, the board proceeding of my lord, ward number 2 and 7 also, my lord. In ward number 2, my lord, the L1 is, my lord, BL Enterprise, my lord. And he was given the, my lord, board proceed, my lord. Agreement was also entered with the BL, my lord, Enterprise, and work order was also issued to BL Enterprise.
Your Lordship, I'd like to point out one very important issue. There's one document which they have that EMD, the EMD return document, Your Lordship. This is the document which they have prepared in backdated. This document is of 8 May 2025, Your Lordship. 8 May. And my representation saying that I may be
Mr. Saikia, you file affidavit.
Madam. And my lord, top of that, my lord, the municipal, Patigat Municipal Council is a body, my lord, created under an act, my lord. And
So
my lord,
it has not been joined as party.
yes, my lord, and the Pasigat Municipal Council is not a party before this honorable court, my lord.
No, the chief is there. The chief municipal council is there.
It cannot be.
The chief councillor cannot be a party here, man. The party is to be the Pasigat Municipal Corporation, my lord, council, to be represented by its member secretary, my lord. It's a body created under the act, my lord.
Let them file affidavit, Your Lordship.
Pardon?
Let them file proper affidavit, Your Lordship, with the relevant documents. I pray that notice.
No, but that's all right, but The proper parties were not joining this petition.
The proper party is the lordship, the chief
Yeah.
councillor, who is the Pasigat Municipal Council. So he is the one who will be the even that is made, even that PMC is made a party.
So who had issued the notice? NIT.
EE.
Executive
EE,
engineer.
yes.
Of
Now,
Of the
Of PMC.
municipal council, man.
and he has been made a party.
It's not a department, man. It's a municipal council, man.
Pasigat Municipal Council cannot be represented by the chief councillor, madam. It has to be
member secretary.
member secretary. Chief councillor can change anytime, madam, member secretary. But the proper party should have been Pasigat Municipal Council represented by the member secretary. Here, the chief councillor has been made the party.
The secretary, urban local body, lordship, he has been made a party. And these are just technical issues.
Pasigat
Not
Municipal
technical,
Council is the
whether,
proper party.
we can pass any order without arraying them as a party in this proceeding.
Your lordship, in the respondent number 1, the secretary of the urban local body, it comes the PMC, it comes under that department. So that has been made a party, the secretary of urban local body.
Better withdraw this petition and file in proper format,
Statutory
enclosing the relevant documents.
body,
Now,
it's a statutory body,
my-
it has to be
my,
the party
my
properly.
submission, my submission, your lordship, as of today, I am not able to procure any documents. And if I go for procuring documents by filing RTI, it will take more than 5-6 months. So if the notice goes and let them file with proper explanation how the tender has been conducted. If they are saying that it has been
No, no.
conducted properly,
This municipality corporation has not been made a party. And if the councillor cannot represent it,
your lordship, if you look at the tender notice, your lordship, it has been issued by the Pasigat Municipal Council. Now, who will head the Pasigat Municipal Council? That is the chief councillor, your lordship. And even the EE who had
elected member.
Member of the council, man. The permanent body is the member Pasigat Municipal Council, man.
and the one who issued the NIT EE, he has been with the party, your lordship. In my
No, see, if we issue notice at this stage, if tomorrow we cannot pass any order, then who will be the
To-
sufferer? You?
tomorrow, yes, your lordship. Tomorrow, if they say that the God party has not been made,
Better withdraw this petition and file in proper format enclosing all the relevant documents.
your lordship, documents I won't be able to get as of now. So tomorrow,
If they refuse to give the information under the RTI Act, you can approach this court
your
or approach the other authority also, appellate authority.
my prayer, your lordship.
Hmm.
Tomorrow, if they say that the relevant parties, the required parties has not been made a party, if on that basis, I might, after due hearing, your lordship, if my petition is rejected, then I'll be okay with that. But as of today, let's notice this, your lordship.
My lord, page 17 is the power of attorney, my lord. Whether this power of attorney can be admitted.
Yes,
Page
yeah,
17.
that can be admitted.
I have seen it.
This is a purported power of attorney by the
My
proprietor of the firm.
my submission, your
This
lordship.
writ petition has been shown by, at page 16 by Yameng Mijay, the petitioner number 1. Whether by virtue of this power of attorney, which is not in the proper judicial stamp paper, ma'am.
My submission, your
Then it
lordship.
is not notarized also.
Not authorized also.
My submission, your lordship. The issue here is whether the process has been duly done as per the law or not. That is the core issue. Now, instead of addressing the core issue, they are trying to raise all these technical issues which is not relevant to the case, your lordship. And as far as this power of attorney which has been given, that is valid. It's not required to be notarized as per the Registration Act. When there is some kind of transfer of property, then the registration is mandatory. But here it is properly written is that I am being authorized to file suit before the competent court of law. So it is admissible, your lordship.
Well, let notice go at this.
Let,
Or
let it
Mr.
be
Ketaza
open for
learning counsel
maintainability.
for the
Yeah, that,
petitioner and Mr. and Ratan Learned Additional Advocate General to the respondent number one, respondent number one, and Mr. R. Soikia for the respondent number three, respondent number three. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the NIT dated 16/4/2025 by number PMC stroke EE stroke 15 12 FC FC 50 stroke 2024-25 stroke 34-42 issued by the Pasighar Municipal Council, Govindagar, and also to set aside the work in serial number 2 of NIT dated 16/2025 for the infrastructure development of ward number 2 of Pasighar Municipal Council, ECM district, being NIT number PMC stroke EE 15 equal FC-50 stroke 2024-25 stroke 02, and also the work in serial number 7 of the infrastructure development of ward number 7, Pasighar Municipal Council, ECM district, having NIT number PMC stroke EE 15 equal FC-50 stroke 2024-25 stroke 07. And to direct the respondent authority to recall the tender award to MSBL Enterprise, within bracket respondent number 5, and also to direct the respondent authority to conduct press NIT to award the tender to the petitioner. First, the petition and the documents plus in record, then notice be issued to the respondents, returnable in 4 weeks. Step upon respondent number 2, 5, and 6 be taken by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 and 3 since Mr. Ratan, Learned Additional Easy, and Mr. Soikia, Learned Standing Counsel for the respondent number 3, entered appearance and received notice. However, extra requisite copy of the petition will be furnished to them during the course of the day. Place the matter after 4 weeks. By same order in item number 5.
In the next day, maintainability may be open for to raise.
The issue of maintainability.
Mr. Ratan, Learned Additional Lazy, and also Mr. Soikia raised a question about maintainability of this petition as the Pasighar Municipal Corporation, which is a statutory body, is not arrayed as a respondent in this petition. The question of maintainability is kept open.
Number 5. The parties are different and the
Okay.
Sufficiently, the fact was exhaustively.
Today you were supposed to argue.
No, I am supposed to give 2 clarifications. Why he has no legal and fundamental right grievances against us. Only 2 pages, then I'll just give some thing on the estoppel why he cannot.
No, on the other day you have substantially argued on this point.
Correct, but that's why just refreshing it, so that only I'll point it out. I'll not take much time, 5 to 10 minutes, maximum,
Okay.
5 minutes.
Yes.
My lord, will kindly come to page 154 straight. Oh, 154, just to refresh. That
Yes.
order, it is last paragraph in the page 154.
Hmm.
It is pertinent to mention herein that no documentary evidence or witnesses being produced by the petitioner in support of his claim for the ownership of Rago area, army occupied area. My lord, remark this. From the claim of the petitioner of having inclusion of 14.826 acres of his Hisam land. Hisam and this plot are two different places, are in two different places where he is claiming. Acquired land, that is
But
14.
his some land is also under the occupation of
No.
the army.
No, no. It is
Different.
clarified. It is clarified in this. That's why I want to read this.
Okay.
14.82 acres of his Hisam land in the acquired land, that is 49.63 acre does not hold ground, as the order dated 12/01/2012 in Basel title suit number 10, stroke 2002 clearly held that the area of the petitioner is only 30.227.87 square meter, approximately 7 acres. My lord will kindly distinguish this. Apart from this particular 49.63 acres of the land decided in our favor, still this particular land is there. Still that 30 acres, 30 square meters of the land is still there. That is approximately 7 acres. So if the entire Hisam land is 7 acres, there is no possibility of inclusion of 14.826 acres acquired land, that is 49.63 acres. Moreover, these 7 acres of the land is not in possession of the petitioner, as he has already sold land to various different private individuals who have constructed their permanent residence in the Hisam area adjoining Armenia, minority markets. This is the catch point in this case. So this particular order has still not been assailed by the petitioner here. This order has not been assailed by them in any manner. Now, my lord, to fortify my argument further, my lord, kindly come to page 171. That Basel title suit. The decree passed in Basel title suit number 10 stroke 2003 by dated. My lord, I'll just request my
You are
lord to
referring to
kind
page number
171, my lord.
that is an order.
Yes, my judgment and order. Decree and order, my lord. My lord, just this is reference, my lord, kindly note BSR stroke TS dash 10 stroke 03, my lord.
Hmm.
And then the operating portion, my lord, I'll request my lord to kindly come straight.
Hmm.
Page 180. Yeah. 180. This is correct. 179, my lord. Here, my lord, kindly see. The schedule has also been given, my lord.
Hmm.
Name of the land, my lord, kindly see. It is distinguishable from here, my lord.
Hisam land.
Hisam land. The area, the area is more specifically mentioned in the schedule here in below, my lord.
Hmm.
Name of the land, Hisam
Liburane, which he is still claiming, my lord. Area 30,227.85 square meters with the boundaries. B, my lord, North BRTF Road, South land of Sri Karsen Lowland, East, my lord, land of Srimati Higam Ango, West, my lord, kindly see. This is my boundary. Villages, army occupied area.
Hmm.
Now, my lord, I am almost finishing, my lord. Page 185, my lord.
Hmm.
One eighty, my lord, can come straight to the page 185.
Hmm. Yes.
My lord, second paragraph.
Hmm.
In view of the above reasons, I hereby order and decree that the adequate land compensation against an area of 49.63 acres of private land shall be paid to the land owners of the PDBRAT-BC villages within a reasonable period from the date of this decree and order without which the area measuring 49.63 acres occupied by army, which is private land belonging to the PDBRTC villages, will be reverted back to its order. Therefore, you know, that allotment order was given to us, all 9 people. The contention which my friend has advanced is not sustainable. Now, we will kindly come to this particular order again. (197) annexure came, you know. Deputy Commissioner has passed. Order dated 17/03/2022, my lord, page 197, paragraph 4, 3, my lord, paragraph 1, 2, 3, 4, 5, 6 paragraph.
Hmm.
The counsel for the petitioner submitted that his client is not demanding compensation, my lord, for 49.63 acres of the land to be acquired for army, but is confined with a demarcation of land and boundary to be cleared between army occupied area and the private land of Sri Kento Esiori at Hisam site. Before release of the compensation as per the map approved by Sri S. Pao, the then Deputy Commissioner West Siang District Alo, and prayed for coming out of his land for the proposed acquisitions. Now, my lord has seen there is one more order which even Kenko Ori, the petitioner himself, appeared before the Deputy Commissioner and say that I have no grievances against the private respondents if the compensation are paid, but the land that is still in my possession is 30.227 square meters of land, equivalent to 7 hectares. So, my lord, after reading these documents, my lord, propositions is coming up. That order, my lord, which I have said is still in force. 49.63 decreed land basal title suit number 03/2008 is still in my pay. The conduct, my lord, by these particular paragraph, my lord, the estoppel comes, my lord. He has no grievances, and in fact, the respondents have been dragged into the litigation unnecessarily, for which they need to be adequately compensated, my lord. So therefore, my lord, I'm coming. Why these repetition in against the private respondents is not mentionable is for this purpose. On the question of, my lord, estoppel. Doctrine of estoppel will come. My lord, just I'm using one gadget where I have put in my note, my lord. My lord, although this doctrine of estoppel is well clear to everybody, my lord, kindly permit me to read in the meantime. The word estoppel is derived from the French word estopper, which means stopper. The term
No,
estoppel
Mr.
was.
Tada, I will see. I will see
Yes,
whether estoppel will be applicable or not.
it will be applicable.
Yes, we will see.
Yes. So therefore, my lord, I just put it one. Well, that estoppel, it is in the Old Evidence Act. It is section 115.
Mm.
Then in the corresponding section, it is 121 to 123 of BSA, my lord,
Mm.
2023. My lord.
Mm.
Now, one particular point, my lord, I want to refer is that kindly see, my lord, that section 11 of CPC, procedure CPC 1908, and section 40 to 44 of the Evidence Act is also estoppel here. And then, my lord, the estoppel by conduct, because of these documents, my lord, they have categorically made the submissions, my lord. If that means, my lord, that's it in the estoppel definition, my lord, part of this. In pies means before the public, and estoppel in pies is also freely translated as estoppel in pies is also freely translated as estoppel by conduct. So your conduct speaks, my lord, in the read petition itself, my lord. Now, therefore, my lord, you have made a submission before the quasi-judicial procedure, which is always done under done under the spirit of the CPC. Then, my lord, the Oath Act comes, my lord. Now, any documents that you file, my lord, it is by means of the section 3 of the Oath Act. You have filed that. Section 3 of the Oath Act, my lord, it is basically to prevent any litigant from filing frivolous documents and also to contain them of the perjury. Look, here is a warning that if you do this thing, the perjury section will be invoked against you, my lord. So therefore, my lord, unnecessarily, my lord, we have been dragged into this particular thing, my lord. So I'll just define, my lord, I'll just request my brother, still you have an opportunity, but then, my lord, subject to again Article 123 of the Limitation Act and the schedule provide therein, whether because long time back, 1962, the land was acquired and then all those declaration was done, whether even in the Article 123 of the Limitation Act and probably, my lord, second schedule, well, 30 years is the limitation. And then again, these will have a repercussion of doctrine of adverse possession. Under whose possession the land is? Definitely not under him. And to fortify, my lord, in my rejoinder, my lord, I have categorically submitted this entire land. Even in the finding of the ADC, the land has the deputy commissioner, he has already sold out the land. So therefore, my lord, if he has any grievances, he is only against the army and the state government. Definitely not against, because the Basel title suit number 03/2010/2003 is still holds the field. This order has not been put into challenge. Suffice to that, my lord, another order which we have read in page 171, right? So that order is also still in force and he has not put into challenge. So therefore, my lord, kindly invoke doctrine of estoppel against him, not to bring us to the litigations, because, my lord,
You are already litigating here.
but as a respondent, my lord, I have to come. We never did that because they are the one who brought us one after.
Okay, we'll see.
Yes. So therefore, my respectful submission is, my lord, these particular interim order, inter alia, to an extent that no interim order, the prayer which he has made to an extent that till demarcation of the land, our compensation shall not be given. That part may be done away with. Otherwise, my lord, the section 321 of the Lara Act is hanging on my head as a Damocles sword. So therefore, my lord, the present read petition is not maintainable against us. Similarly, my lord, my brother was referring to read item number 7, that is read petition 591. Where is the course of action?
We are not hearing
No,
that.
no, just I'm making a reference.
Because the state has not filed their affidavit.
Well, to this extent, to my understanding on the factual metrics of the case and the various principle of law if applied to, and on the records, my lord, there is no case against us. So therefore, the deputy commissioner may kindly be directed to give us the compensation only in respect of, my lord, 49.63 acres of the land which is under the possession of the army. Grateful.
Yes, madam, what is your submission?
Lordship, only I have to say, Lordship, my affidavit in at page 64, Lordship, that there was. Lordship, here in this is Deputy Commissioner's order only, 17/3/2022. Lordship. From the beginning, Lordship, the petitioner is
Page number 64.
64, Lordship.
Yes.
Deputy Commissioner's order dated 17/3/2022, Lordship,
No, no.
it is
No, 64 is not the.
my affidavit, Lordship. My affidavit.
Your affidavit. Okay.
Respondent number 3 and 5, Lordship.
Page number
64, Lordship.
64. Yes.
Lordship, here, from the beginning, petitioner's grievance is that the demarcation should be done. Here, Lordship, even here it has been recorded, Lordship, the counsel for the petitioner submitted that his client is not demanding compensation for the so and so land to be acquired for the army, but is confined with the demarcation of land oblique boundary to be cleared between army occupied area and the private land of Sri Kento Asi at Hisam site before release of the compensation as per the map approved, Lordship, by so and so. Lordship, that and Deputy Commissioner. Accordingly, Lordship, in the next page, Lordship, the Deputy Commissioner have stated that in the light of the above, I am considered of the considered opinion that since petitioner has only appealed for demarcation of boundary and that the respondent has no particular objection to this appeal, a demarcation may be conducted to settle the case at the earliest based on the latest approved sketch match of the area against which preliminary notification has been issued, Lordship. This was ordered also to the DLRSO. But then after this, they have the petitioners have gone to the High Court, appeal before the High Court. It has to stop, Lordship. Next page, Lordship. In pursuant of the Honorable Court, that is so and so passed in WPC so and so, Lordship. The boundary demarcation of army occupied area so and so is fixed on 18/4/2022 is hereby cancelled because they have gone before the appeal before the High Court, Lordship, against this order again, Lordship. Lordship, my here submission would be that if the demarcation is even at this stage, if it is directed to the Deputy Commissioner, all the Lordship, this case will be, Lordship, come to end, Lordship. Unless demarcation is done, Lordship, wherever they go, since this is disputed question of Lordship fact, Lordship. And in the statement also we have said that, Lordship, we were ready for demarcation, but because the petitioner, Lordship, have gone for appeal against the Deputy Commissioner's order, the appeal demarcation couldn't happen, Lordship. And petitioner has again and again, Lordship, challenged the landowners, these 9 landowners, how they have been given land ownership certificate. To that, Lordship, in my affidavit, we have only said that this is the outcome of that public hearing. And that statement is, Lordship, in yes, my paragraph 18, page 46. page 18. This much only, Lordship. Paragraph 18. In the instant case, the name of the 9 landowners is the outcome of public hearing dated 16/7/2019, as already stated above. And my Lordship, my submission would be that only, as I have already said,
Okay.
demarcation.
Yes, Mr. Modi, any reply?
Yes, whether union should be given an opportunity, madam. Union are also appear whether.
You have a respondent
They have,
number?
yes, they have denied to.
Forensic.
We are not specific party here.
Okay,
We are user agency lawsuit, and it is the state government who will provide us the land.
okay,
Whether the land belongs to the petitioner or private respondent, we are not concerned with that. We required 49.63 acres of land for establishing our headquarters, and we are ready to pay compensation for that area only. Lawsuit.
okay. Okay,
Yes.
yes, my lord. In fact, my lord, I am not supposed to submit much today, but despite of that, my lord, on the basis of the my lord submission, I have to reply, my lord. And just for my lord proper adjudication, I have made the list of that as part of chronological events, man. So that will helpful to this one court to find out what is the fact exactly in this. Yes. So, my lord, without going into the merit, what has been argued, but for the as sorry, ma'am. Now, first of all, I will reply as per the argument point of view, what the respondent number 7 collect. Respondent number 7 has replied, my lord. I'm sorry to say, my lord. In fact, I thought that the respondents are trying to mislead this court by confusing the fact. But now I'm sure that they are trying to confuse the court by mixing the facts, which is, my lord, which should not have been done. In fact, my lord, first of all, they report page number 171. What? Reporting in the page number 171 is the title suit pertaining to the title suit number 10 of 2003, which is completely different from the other. And their submission is that since you have not challenged that title suit, where is your right? I don't understand, my lord. Why I should challenge, my lord? This is the title suit whereby I have been granted, my lord, the land measuring of 30,227.86 square meter has been, my lord, declared in my paper at the Hisham area, my lord. So why I should challenge? This is, my lord, both the title suit should not be mixed up. First title suit is title suit number 10 of 2003, whereby, my lord, I am the petitioner and the other party is the, my lord, this Digatatil. Thereby, my lord, this is clear. What has been read out, my lord, location is there, man. And why I should challenge, man. Secondly, my lord, at the same time, now, correct point to understand by this court is entire epicenter of the case is start with the withdrawal of title suit number 59 of 2008, my lord. So this should not be, my lord, mixed with title suit number 3 or title suit number 10 of 2003 and title suit number 59 of 2008 should not be mixed up. Now, as my brother has read out, while my lord, the title suit was withdrawn, I have never challenged and I have never stated that. I am wholly supported that that was withdrawn with a condition. So, my lord, I take to the court my lord, just to refresh again. That withdrawal was, my lord, unconditional. My lord, my brother has read out the page number 185, which is, my lord. And I would like to start from page number 184. And my lord, para 1, 2, 3, 4. Para 4, my lord. Kindly see, my lord. Para 4. During the pendency of the cross-examination of the deposition of PWA in the chiefs, where the parties and affidavits of the petitioners recant or withdraw from contesting the case in favor of the PDBRA TBC Boundary Committee. Subsequent to the withdrawal of the contest of appellants on the settlement of the dispute outside the court through the negotiation between the parties, my lord. This is the, my lord, reason why I have withdrawn. On the conditional, this has been withdrawn, my lord. This negotiation between the parties, option left to this court to confirm the title in favor of the, my lord, this respondent. And so far, my lord, that I am not on question. I am saying, yes, it was withdrawn on the condition, man. Condition was very clear. This withdrawn was made on the basis of settlement between the parties outside the court, man. Point to be noted, man. Now my question is, thereafter also, my lord, may kindly come to the page number 185. Third para, my lord. I will skip which is not necessary. In view of the above reason, I hereby declare that the adequate compensation against the area of 49.63 acre to the private land shall be paid to the owners of the TBC villagers within the reasonable period from the date of this degree and holds without the area measuring 49.63 acres occupied by the army area to the private land belong to the PDBRTC villager will be reverted back to its owners. Direction is very clear that these PDBR, my lord, poor villages, the peoples of the poor villagers were supposed to be owners of this, were supposed to be get back. But despite of that, now, this PDBR become, these committee members become the landowners. But till that also, to that extent also, I am not questioning. I have withdrawn in favor of the committee, and committee supposed to identify the landowners of the poor villager. Now, why I have withdrawn, my lord? What is the condition that this title suit measuring 49.63 was withdrawn? As my lord, I have also shown to the day before yesterday. If my lord come to the page number 135. 135, my lord.
No,
My lord,
you have
yes.
already pointed out this. You have
My
already
lord,
argued on this.
Why? What is connection is that this is very clear that I have to acquire 100% of the Hisham is, my lord, in my favor, and that should be, Hisham should be my personal land, my lord. Now question is only, my lord, what is attached with is, my lord, I have been demanding since 2020 or since 2010, 12, 13, that the land which is under occupation of the army area and the Hisham area is has not been divided, my lord. Therefore, I am asking for the demarcation since time from very beginning, because some portion of the land measuring about 60,000 square meters within, my lord, occupied area of the army. In such situation, my lord, why I am not there, man. Therefore, now the question is that whether demarcation has been made or not. Now, after submission of the government and the record, my lord, this in the Ipsalocutor, my lord, clearly speak, demarcation has not been made. Until and unless the demarcation has not been made, my lord, the Hisham so-called, what is Hisham and what is army land? That has been already been, my lord. That landmark decision was given on 21/8/1999 by the Deputy Commissioner, and the same has been accepted by this Honorable Court in WPC number 197 of 2005. Therefore, to separate the Hisham from the army occupied area, that already the Sham pillar post is there. Other than in addition to that pillar post, now the one road is also there. So I have only limited prayer that Deputy Commissioner need to consider my case, that some portion of my upper portion of my Hisham area is, my lord, within the army occupied area. Despite of that, my lord, my name is not in the beneficiaries list. That was my objection. If army is not ready to compensate me, my lord, my part should be discarded out. That has not been, my lord, done. Therefore, my lord, I am agreed with the government that this demarcation be, my lord, done as per the decision of, my lord, 21/8/1999. That, my lord, description has already met. The land sloping area, which is sloping area next to the approximately the slope area is 120 degree like that. And entire sloping area is belong to me, that is the Hisham. And the plain area, plain portion is army occupied. Now, Alo Township has already been decided. Alo Township has extended up to Degong Korong Mile. Therefore, if the measurement is start from the one Degong Korong Mile, that is the one natural nala. If that start from natural nala to that mile, 49 acres is covering under my land, undisputed land, which has been handed over to me. That is only my case, my lord. But the same has been repeatedly, my lord, rejected by the Deputy Commissioner, that you have no land, you have no case because you have already withdrawn. I accepted I have already withdrawn my title suit on the ground that Hisham belonged to me. Now Hisham is... Okay. And finally, my lord, and the last submission, board has referred the judgment passed by the Deputy Commissioner of 17/3/2023. And my submission in the argument point of view, my lord, this will be not sustainable on the ground that this particular order passed by the Deputy Commissioner has been already quashed by this Honorable Court. Therefore, until and unless the particular order which already been quashed by this court cannot be relayed, my lord. I am being aggrieved of the order passed by the Deputy Commissioner. I am here before the Lordship, and the Lordship has already quashed. Therefore, taking this, my lord, order which already been quashed cannot be, my lord, sustainable.
Okay.
So, okay. And my lord, lastly, my lord, one more, my lord, since item number 7 is also argued by the government, on the last occasion also, from the day one also.
Item number 7, we are not going to dispose of it. They have not filed their affidavit. Without their affidavit, we will not.
Otherwise, my lord, it seems that now the rule has changed despite the game already began. In fact, my lord, That is my prayer that until and unless you have not filed this affidavit in opposition, this item number 7 should not be heard. But despite of that, the party has unanimously agreed to
If
this
you
process.
want both the matters to be heard
Therefore,
together,
my
then
lord.
I can release it from part
My
one.
lord.
I have no problem.
And they have already argued, my lord, in the item number 7 also, WPC number
If
491.
Still, you have any objection in hearing this matter?
No,
After segregation of the thing?
That was not. So, my lord.
Only after consent of all the parties,
Mm.
this repetition number 492 was taken up for
Mm.
So there was no whisper about 591.
Mm.
Any outcome, that's consequences will follow.
Mm.
So why, in fact, my brother only made the earlier submission that, okay, we start with 492.
It's the amount, my lord, change the rule
No.
once
We
the
have not
games
changed
started.
anything.
With the concern of this,
We as a court officer, we should be very honest.
otherwise what?
It is not representing the client, but our moral ethics responsibility is before the court as a court officer. Well, only one thing, that boundary thing I want to clarify.
Mm.
Can we have this, can you note it down on the,
Mm.
that NHL 3 series page?
No, you furnish a copy to the court
Yes,
master.
well, it's already there in my rejoinder,
In your?
in my rejoinder. Affidavit in opposition. Page 31.
So, my lord, 491 is not disposing, 591.
But this boundary has already been demarcated.
Page number?
Page 31 of my affidavit in opposition.
Well, they are the private parties showing that the demarcation has met. But at the same time, government is still saying that recently the demarcation has been cancelled, man. Demarcation is yet to be conducted, man.
Not confused with. I'm not reported this. Well, kindly see page 31, 49.63 A plus B, Army square.
What is the affidavit? You are for respondent number 7.
7, bro.
Page number?
Page number 31.
Yes.
This is kindly see in the box, below. The highway goes below. There is a small line below. The other side is that is Isam area below. This is not, this is purely Army area.
Mm.
A plus B below. A is 12.21 acres. And then that A plus B is this thing, 49.63. That is absolutely fits into the scheme of Basar title suit number 10/2003. And then, my lord, I also forgot to, yesterday I indicated, well, my lord will kindly take on board page 187 of the repetition, that preliminary notification.
Mm.
My lord, paragraph 3, line 2, my lord.
Mm.
Whereas it appears to the governor of Arunachal Pradesh that land is likely to be rendered as the locality more described, setting of history, infantry brigade quarter on an area.
No, you have shown this paragraph to me on the other day.
Yes, that's why it just, I just
87,
forgot.
187.
One more refreshing is page 191, where in the first count he made that we have no objection against the respondent for getting the land compensation. This is by himself, the petitioner himself, not by the council. Para 2, page 191, order dated 0/12/2021. On the very outset, Sri Kento stated that he has no issue with the BRATBC getting the land compensation, and also that he is not claiming the title of land occupied by army. Waiver, stopper and waiver.
This was also said as said, already said as said in WPC 1.349.
Don't tell lie. This is your conduct.
But Mr. Modi learned counsel for the petitioner and Mr. T.T. Tara learned counsel for the respondent number 7 and Madam Ite for respondent number.
Lordship, I'll be for 3, 5, one,
And Mr. Lawyer for
1, 2,
4 and 6.
4 and 6.
3, 4,
And the rest of
1, 2,
the
3 lordships
okay.
and 5.
Argument concluded, order is that.
Good.
All right. In next item, you take down.
Apply.
Heard Mr. C. Modin, learned counsel for the petitioner. Then Madam Ita for respondent number 7. And Mr. Lawyer for respondent number 7. Office note dated 31/5/2025 indicates that affidavit in opposition is yet to be filed by the respondent number 1, 3, and 5. Accordingly, it is provided that Ms. Vite shall file the affidavit in opposition within without further delay. I'll list the matter after 3 weeks, madam. Affidavit. In this matter, affidavit.
Apply.
In this case, I am appearing for a petitioner in both the cases. And respondent number 7, he has filed his affidavit. And respondent number 1 to 6, not yet filed any affidavit. So pleading is not yet completed.
Pleading
Pleading
not completed.
not completed. Because respondent number 1 to 6, they have not filed any affidavit.
Who is for respondent number 1 to 6?
Government.
Government is there.
Government. You are for respondent number
7.
7.
They filed the affidavit, verifying everything.
Mr. Nadam, are you going to file affidavit?
Affidavit, my lord, yes, my lord, we are yet to file the affidavit. Actually, what happened, my lord, we have already communicated to the department. Comments is not coming forward, my lord.
Okay.
So, your lordship may either give us 2 weeks more time to file the affidavit, or else, my lord, we will produce the record, my lord, since this is a NIT matter, my lord.
Okay.
So, we need some more time. Actually, I asked my junior to answer.
Heard Mr. M. Pertin.
One more thing, my lord. This is, my lord, the private respondent, they have filed the affidavit. My lord, copy has not been served to us.
Tada is available furnished copy.
That copy, one copy.
Furnished without file. We have furnished to the.
Petitioner, not to the respondent. We are selling together.
Affidavit. Affidavit.
Affidavit we need not to give to the government.
Huh? Very strict.
I'll serve it.
Fine, but the critical is there is an interim order operating. Yes.
Interim order is operating against?
1-4.
Because the effect is something different, but there's something like I will not open up today.
1-4, since 1-4, 2025.
Okay. Heard Mr. M. Pertin, learned senior counsel assisted by Mr. Learned counsel for the petitioner and Mr. Riram for respondent number
7.
1 to 6.
1 to 6.
And Mr. Tara for respondent number 7.
7.
Mr. Rirama, within 2 weeks you have to file the affidavit. Yes. Or you have to produce the record.
Yes, sir. Either record or affidavit.
Okay.
Well, let it be on 17. We
7.
give them sufficient time.
Okay.
Yeah,
Mr. Riram, learned counsel for the respondent number 1 to 6 submits that he may be granted 2 weeks time to either to file affidavit in opposition or to produce the record before this court. Where is accordingly allowed? SSL is the matter on 17.
17.
Okay.
My lord, kindly make an observation. If the government fails to file affidavit without affidavit, endeavor shall be made to dispose of. Because my affidavit is very clear.
My lord, that is what I is saying, my lord. My lord, your lordship may give us 2 options, my lord. Either we'll file the affidavit or produce.
No,
the
no,
record.
I have given the 2 options.
My lord, very well, my lord.
Either to file affidavit
Or
or
we
to
produce the record.
produce the record.
Very well. Yes, Your Lordship.
Yes.
Lordship, in this case, the petitioners in this case are surviving their livelihood by doing small businesses. Now, in order to earn their livelihood, they have to obtain on permission to conduct Mela.
No, the period for which permission was granted to you, that has already been over.
No, Your Lordship. The days are over, but then my Mela is not running, Your Lordship. One thing is admitted, the machineries are running, but the Melas were.
No, because your machineries are there, they may not extend it. No?
Your Lordship.
In the meantime, government has taken a decision not to extend.
No, now,
Sorry.
now Your
Yes.
Lordship, my submission is that after the permission was after the permission was withdrawn, no further permission given to me. Thereafter, my Mela was not functional, Your Lordship. The machineries were functional, Your Lordship, but the Melas were not functional. The difference I'm trying to say, Your Lordship, is that I have to sit on the motors and that, but it was not open for public, Your Lordship. That is my grievances. So as of today, Your Lordship, I'm only saying that I may be given 20 days time, Your Lordship.
What? 20 days for?
To run the Mela openly.
To
run the function of the Mela openly, Your Lordship.
No.
Now, Your Lordship, if we look at this order, Your Lordship, the order which is this is concerned only with, I am concerned only with the Mela, Your Lordship.
So on 10th of March, your terms over.
Yes. But in the meanwhile, Your Lordship, my Mela was not functional, Your Lordship. That is my submission.
No.
And Your Lordship, my one submission, Your Lordship, is that in this petition, I'm challenging only in respect of the Mela. Now, if we look at in the entirety of this order, Your Lordship, it is more illegal, Your Lordship.
How?
Because they have cancelled all the permission to conduct weekly markets, Your Lordship, which is total violation of the Article 19G, the right to
No,
which I
that's
believe,
a
Your Lordship.
different matter.
Yes, Your Lordship.
You have been granted permission from 10th of April to 10th of May.
Yes,
That period is already over.
Now, my prayer, Your Lordship, is that I was not given extra permission, Your Lordship.
Extra?
I mean, once the permission was lifted, my Mela was not functional, Your Lordship. The machineries were functional, Your Lordship, but Mela was not functional, Your Lordship. That is
No, it is your business. How can you?
So therefore, Your Lordship, I only felt that if I maybe given at least 20 days to function my Mela, Your Lordship.
No. So after expiry of the term, whether you have applied for granting for extension of the permission?
No, because Your Lordship, I was not given permission to conduct the Mela, Your Lordship. When my permission was
No,
suspended.
whether you have filed any representation before the authority to extend the pair, extend the tenure.
I submitted on application, Your Lordship.
When?
Seeking permission. There is on page number 20, Your Lordship. Page 20.
Page number?
20 of my application.
Page number 28 is their part of the affidavit.
Of my petition, Your Lordship.
28 is not there in your petition.
Your Lordship. Page 20 of my petition, Your Lordship. Page 20 of my petition.
20?
Yes, 20. To this application, I saw
Mr. Luang, what is the outcome of this representation?
no correspondence, Your Lordship.
No idea.
No idea. You obtain instruction there.
About the representation.
Yes. What is the status of this representation dated 5/5/25?
Actually, well, this public service given for a period of these things.
No, that's all right, but whether you have disposed of this representation. Pardon me, sir. Taza, learned counsel for the petitioner, and Mr. N. Law, learned senior government advocate for the state respondent. During the course of deliberation, Mr. Taza has pointed out that though the period for which the permission was granted to conduct the Mela expired on 10th of May 2025, yet before expiry of the said period, he filed on a representation to the Deputy Commissioner Pasighat on 5/5/2025, and the same has not yet been disposed of by the respondent authority, by the Deputy Commissioner. Accordingly, it is provided that Mr. Loang, learned additional government advocate, shall obtain instruction regarding the present status of this representation dated 5/5/2025 filed by the petitioner to the Deputy Commissioner Pasighat, East Siang District, Arunachal Pradesh, and applies this court after 1 week on date.
Lagi Rasif.
My lord had already devoted a huge amount of judicial time in this matter, so I'll cut it very short, my lord. Our initial objection at the time of admission of the appeal was that, my lord, earlier,
Both these appeals are yet to be admitted.
yes, my lord. The earlier
And one is prepared by Deputy Commissioner.
and one by the revenue department.
By the Revenue state. Department.
State of
Revenue
Arunachal
Department.
Revenue Department. We said, my
So,
lord, but my proposition, my lord, is that initially we objected, my lord, saying that earlier, my lord, under the section 54 of the 1894 Act, there was no definition as to who could file an appeal. So
No, no,
therefore, any person, my lord, could
Mr.
file an appeal,
Pathak, there is a decision of this court
my lord.
delivered by Justice Sanjay Mehdi,
My lord.
where it is stated that
No, in this matter, my
Deputy
lord,
Commissioner cannot file any
my
appeal.
lord. There is some development in this matter, I have to frankly submit, my lord, because this was a land acquired for CRPF. CRPF was not made a party before the reference court. So CRPF then approached the reference court directly to the Supreme Court. And the Supreme Court said that no, this matter, since the requiring body is a necessary party, the entire reference has to be remanded and it has come back to the reference court now. So this will not probably, though this aspect of the matter as to whether DC can file or not has not been touched upon by the Supreme Court. So let us,
This matter is
Horizontal.
Deputy Commissioner versus Horizontal.
Horizontal. Yes, I'm aware of that. But then
Yes.
Supreme Court has, my lord, sent back the matter now because CRPF was not heard at all. And in a SLP filed by CRPF before the Supreme Court, the entire matter has been remanded back to the reference court again. I was following this, my lord. So my proposition, my lord, here is that rather than going into this interpretation, now section 74 says that requiring body or person aggrieved. So whether DC is a person aggrieved or not, my lord, rather than going into interpretation of section 74 at this stage, my lord, my thinking is that, my lord, what if, my lord, if the state had not filed an appeal? Then, my lord, Order 41 Rule 22 still covers the matter, saying that the respondent, while hearing of the appeal, can still object or defend a particular decree as if they are, my lord, in the same pedestal of as if having preferred a separate appeal. Lordship will just read Order 41 Rule 22 that upon hearing, respondent may object to the decree as if he had preferred separate appeal. Any respondent, though he may not have appealed from a part of the decree, may not support the decree, but may also state that the finding against him in the court below is in respect of any issue ought to have been in his favor, and may have also taken cross exception to the same. He could have, to which he could have taken in a way of appeal, provided he has filed such objection in appellate court within 1 month from the date of service and so, or within so and so. So as if, my lord, a separate appeal has been filed, the same provision is there in, my lord, Order 41 Rule 33 also, in powers of appellate court. The appellate court can still hear the respondents as if they had preferred a separate appeal, irrespective of the existence of these two appeals. Now, since my lord has already heard the main appeal preferred by the Union of India, who is the person actually affected by this decree, because they are the persons who have to pay, my lord, if at all they have to pay.
So since that appeal has been heard, whatever decision your lordship will now take in that matter will naturally govern these other two appeals also, my lord.
You are referring to order?
Order 41, Rule 22, my lord. Let us, my lord, not decide and argue on this. We have spent already a lot of time in this appeal. Because the state's objection cannot be different from the union's objection, as far as the defense against the decree is concerned. So they may be treated to be as being heard in the main appeal that is, my lord, filed by the Union of India. Because they are a party there. As a respondent, they have place or they would advance their arguments therein as if they have prepared a separate appeal, my lord. And that decision will govern these two. There cannot be any other contrary decision in these two appeals, my lord. So in that way, my lord, probably this should be now left aside and we will await my lord's verdict in the main appeal, my lord. Because if we argue on section 74 and its interpretation, it's going again going to take time. And it would be a wastage of judicial time because on the other aspect, the main appeal, lordship had already heard, given considerable amount of time already.
Yes, Mr. Sophie.
My lord, here, of course, that item 11, my lord, I'm appearing for the state, my lord. Now, my lord, that I've been submitting on the other day also, I've submitted, my lord. In the LA appeal preferred by the union, man, I'm appearing for the their response number 105, the statement. Now, my lord, what has happened, my lord, in that, my lord? The merits have not been argued upon, my lord. Basically, the argument advanced by the ASG was on the maintainability of the reference itself, man, and regarding the power of attorney. So, since merits have not been gone into, and my elder brother has also not gone into merits, man, we have not advanced an argument as such, man, in the LA appeal preferred by the union, man. Now, my lord, otherwise also in the reference, my lord, the state has not taken the stand regarding the power of attorney also. Our stand is limited to certain aspects, my lord, regarding section 26(3) only, my lord. That has not been argued into, my lord. That merit has not been gone into in the LA appeal. That is the difficulty, my lord. We have not raised any issues about the that power of attorney before the authority. Now, our day before yesterday, my submission was that since merits have not been gone into in the LA appeal 1 of 1 that filed by the union, my lord, we are at a disadvantage, my lord. And as far as maintainability, regarding maintainability, of course, that judgment by this report in GLR also, my lord, but deputy commissioner, my brother here is representing, man, but I am representing the state, man. That person aggrieved or whether the state can be a person aggrieved or not. That is issue, my lord, that was raised. So today it is here, my lord. That's why we have not been heard so far, man. Because the maintainability was there. Now, so if your lordship today says, no, we will not hear this matter since the LA appeal has already been heard, that filed by the union, man. We are in a slight disadvantage, man. We have not been able to put forward our grievances, man, because the merits have not been gone into in that appeal, man. That is our difficulty.
Then what to do? Suggest the course of action.
Well, today, my brother.
That is why after the learned AZ had argued only on 2 points, I had the questions that whether the entire hearing of the appeal will be restricted to these 2 issues. Because appeal has to be heard in composite manner. And if they are urging only these 2 issues, then I can only reply to these issues.
Lastly, he has submitted one written synopsis of argument. He has raised several points there.
My lord, I have not got a copy, my lord. I will probably request the copy, my lord, from Mr. Lord.
We have never been heard because that issue regarding the mentality, and my elder brother has also said, man, during that at the time of the hearing of the LA appeal 1, man, this can also be heard, man, regarding the mentality also. So far we have not advanced any argument also, man, and our dilemma is already.
Now, what is your submission? You tell me.
My lord, that these appeals need to be admitted and we also need to be heard, my lord. Our is basically grievance of the state is
No,
limited.
the other matter has already been heard.
Yes, my lord.
Hmm?
We are in a awkward situation, my lord, because of the developments in the LA appeal one.
And before starting argument, you could have pointed it out that these two matters has to be heard first.
No, my lord, that has always been our submission that this needs to be
But on
heard.
the other day, you have not submitted.
My lord, my brother was also here, my lord, but
No, he has also not pointed it out.
it was pointed out that this is
So
the analog.
only after argument, it has been pointed out that two other appeals are there yet to be admitted.
Actually, my lord, that is why probably order 41 rule 22 was devised. Because the law does not contemplate filing of multiple appeals against the same decree. This is the unique case where multiple appeals have come. But then essentially, lordship has to see whether that is correct or not. Decree is to examine. It has to be examined. And they, as a respondent, has ample opportunity in the appeal filed by Union of India also to submit as if they are preferring an independent appeal. That power is there. This avoids multiplicity of litigation, my lord. That is why this was devised.
You have been right in the LA appeal number 1 as a party.
Yes, party. We are a party there, my lord. But that's why, my lord, the situation that we are in, my lord, since the arguments have only been restricted to 2 points regarding the power of attorney.
Maybe it does not mean that you will not be able to argue on the other points also.
No, my lord, that is there, my lord. But my lord has seen, my lord, how the matter has proceeded, my lord. Yesterday also, and day before yesterday also, my lord. My lord was sitting till 4:35, my lord. And my brothers, they had not completed their argument also, my lord. Yesterday also, my lord, there was no time for us to argue also, my lord.
But
Yesterday,
you do one thing, you submit your written argument then, highlighting all the points.
my lord, and our is very limited, my lord.
Okay.
Whether that, since of course that has not been gone into, that merit, the aspect of merit has not been gone into, man. But whether the authority was right in relying upon those unregistered sale deeds while arriving to an price and etc.
You file a written argument then. We'll consider it in both the matters, in LA number 1 and these two matters.
Yes. Their objection was to rate only, madam, and how the rates were fixed, because 2022, I had pointed out, they had brought out a notification which notified the rate again to be 150.
Okay.
And our grievance was that in 2012 also it was 150. How come in 2022 also it is 150 without any escalation?
So within 1 week, you file it to the register
Man.
and he will transfer it to the principal seat.
Man. I'll do that.
Yes.
In this matter, my lord, your performer respondent from 104 to 107. So here I adopt the submission forwarded by recent Solicitor General of India. And he has forwarded two judgments. My lord, I claim.
Regarding maintainability.
Yes, this is. Now, this is actually who can file a appeal regarding that. The stranger cannot file a appeal. The paragraph number is already given by.
They are not
Stranger can also file.
But they have additional Solicitor General direct me to forward to your lordship.
Stranger,
They are not
that is of
stranger.
course settled, but here the issue would be whether who can be an
The
aggrieved
press
person.
course was therefore actually to take cross objections under Order 41 Rule 22 rather than filing a separate appeal. That is treated as a mild separate appeal altogether. Instead of registering separate appeals, my lord. Even if section 74 and its scope is not gone into, they still have a right. I'm never saying that they don't have a right to, my lord, object to the decree. They have a right, but then the manner.
Okay. So we conclude the argument then.
That can be. Then, my lord, then we'll be filing our written argument in that LA appeal 1, my lord.
Both the matters.
Okay, man.
Okay. Yes.
Man.
Both the
You
matters.
can make it combined actually to cover both the cases.
All right.
Okay, we will pass necessary order.
Man.
Next item.
Okay. Maybe, okay.
None appears for the petitioner on call, lays the matter of the 1 week.
Wait, please, Lordship. My lord, I'll make it just 3 point before you, Lordship, my lord. Number one, my lord, the 164, that is page number 11, my lord. The prosecutor has made so many contradictions, man, in this statement. Yes, my lord, 11, my lord, page number 11 of my paper book, my lord.
Yes.
It is recorded by the magistrate under section 164 CRPC. Or not, I am to state that I am staying at the residence of my Didi, that is sister, Miss Parabani Mongkang at Lathau village, Namsae. My parents are residing at Chokang, but I do not know their names and their exact locations. I came to the house of my Didi about 1 month back. On 16/3/2021, I went to the house of my auntie, Didi's elder brother, a sister, located at Lathau village. While I was returning back from there, I was followed by the accused on the way. Suddenly, he punched upon me, dragged me towards the bushes, threw me on the ground forcefully.
Mr. Swan,
My lord.
your primary contention is that there is discrepancy in the evidence of the victim girl.
Yes.
With her counsel assisted by Mr. Learned Counsel for the petitioner and Mr. R.S. Napam, Learned Additional Advocate General for the state of Arunachal Pradesh. Respondent number 1 to 5.
6 and 7, my lord. My junior here, my lord. He knows. NSPC, my lord, there is no standing counsel as such, my lord, from case to case. So DG will have to be, he approached one, said no, unless we get instruction, we cannot accept notice. So DG will go by registered post.
Mr. Barbara, Learned Counsel for the petitioner submits that the two petitioners are the owner of 315 hectares of land in Dambuk Circle. And out of the said plot of land, the Government of Arunachal Pradesh has issued a notification on 27th of August 2013 under section 4 and 6 of the Land Acquisition Act 1894 and acquired 66.68 hectares of land.
66.68, yes.
From
66.68.
Yes.
Yes.
Out of the petitioner's aforesaid parcel of land for the purpose of Dibang Valley multi-purpose project in the lower Dibang Valley district.
Lordship may refer to the settlement agreement.
For the user agency, that is National Hydroelectric Power Corporation within bracket NSPC Limited, by paying appropriate compensation thereof. And the petitioners and the user agency has entered into an agreement on.
Is a tripartite agreement, petitioners, NSPC and government.
With the user agency and also with the government on 1st of December 2021. copy of which is annexed as Annexure B at page number 28 of the petition.
Including the schedule.
Thereafter, Mr. Barbara further submits that thereafter, the petitioner noticed in the month of October 2023 that along with the ongoing construction stroke installation work undertaken by the NSPC in 66.68 hectares of land originally owned by petitioner and lawfully acquired by the government of Arunachal Pradesh, the NSPC suddenly started cutting various
NSPC throw it
medicinal
as an
plants, medicinal plants, standing mature trees, timbers, bamboo groves, and fruit gardens of the petitioners.
valuable trees. Mature trees, man,
petitioners'
consume along.
land falling outside the area of 66.68 hectares of acquired land without their knowledge and consent and without any communication whatsoever either by the government of Arunachal Pradesh or by the NSPC and its associate entities. Mr. Barbara further submits that the petitioners have filed various representation, including the Chief Justice of the Chief Secretary to the Government of Arunachal Pradesh, but the same failed to evoke any response. And being left to it, the petitioners approached this court by filing the present petition. Mr. Barbara further submits that in respect of cutting trees and other construction and installation work undertaken by the NSPC over the 66.68 hectares of land, he has no objection. But the petitioners have no objection, but the petitioners have objection in cutting various medicinal plants, standing mature trees, timbers, bamboo groves, and fruit gardens
In violation.
over the parcel of land outside the area of 66.68 hectares of acquired land.
In constitutional violation of my rights under 300A.
And thereby violates the rights of the petitioner guaranteed under Article
300A
and
of the Constitution, my lord.
300A of the Constitution of India.
And other fundamental rights.
And other
fundamental rights, my lord.
And fundamental rights guaranteed by the Constitution of India. And therefore, Mr. Barbara submits that this notice may be issued. Notice may be issued and the respondent authorities may be directed not to undertake any works and also cutting of trees beyond the area of 66.68 hectares. Mr. Navam Learned, Additional Advocate General for the State of Arunachal Pradesh, also submits that this notice may be issued and you file one report. I'm sorry, I did not get it. Report. Whether any activities is being carried out beyond the area of 66.68.
Lordship may also have a look at page 21 of my petition, my lord. That I think I'm just assisting your lordship, my lord.
Page 21.
Page 21, paragraph 17. This is in the meantime, the ultimate what relief I get is different thing. It is a fit case wherein lordship may please to direct government respondents to make a field survey comprising of responsible officers from concerned departments and authorities. It's a very reasonable thing, my lord. And then produce it before your lordship.
Okay. After hearing learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record. And taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to issue notice to the respondents by registered post with ADS also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 125 since Mr. Nabam entered appearance and received notice. However, extra requisite copy of the petition be furnished to Mr. Nabam during the course of the day. Further, considering the submission of learned counsel for both the parties, it is provided that the respondent number 126 shall make a field survey comprising of responsible officers from the concerned department and authorities in presence of the petitioners
Village headman,
and the village headman
and the neighborhood community people. Well,
Why not especially with the petitioners, my lord? That will be more authentic, my lord.
yes, petitioners.
in presence of Gawra also.
Rangbura, my lord, he represents the my lord, government, my lord.
Government.
He's a government appointee, my lord.
Even then he should be there. No problem. Other people going on inspection also government engineers.
Now, what about the petitioners, my lord? Someone should be present there on the spot.
Yes, petitioners will be there
Yes,
in
ma'am.
presence of the petitioners.
And a submitted report
And
before your
to
lordship.
submit a report within a period of 2 weeks from today.
Yes, ma'am.
No, from the date of
Date of receipt of the
certified
my
copy
lord.
of the order.
Before your lordship. In this court, my lord, let them produce.
Okay,
Lordship will see.
okay.
Then the question of my relief and all the
Okay.
damage and all
Before
this.
this court, okay.
And till then, my lord, no further damage of the topography.
Okay. Further, it is provided that till submission of the report, no activities should be carried out beyond the area of 66.68
Of acquired land
hectares of land
owned by the petitioner
owned by the petitioner
and not acquired by the government.
and not acquired by the government. List after 2 weeks.
Of liability.